It's unconstitutional to deny people this choice.
There will be people who would have gotten better, who will now have their life ended.
And I'm terrified of the dangers of reckless expansion.
This is making sure that all Canadians have equal opportunity.
From the Zoomerplex in historic Liberty Village, the Zoomer with Libby Znaimer.
Welcome to the Zoomer. I'm Libby Znaimer. Canada's 5-year-old law on medically assisted dying is getting an update, but like everything associated with death, the issue is emotionally charged. At the heart of the controversy is expanding access to assisted dying. Our panel will speak to the question of by how much. Now, the need for changes was sparked by a Quebec Superior Court decision that declared part of the current law unconstitutional. The government is now in its 4th extension of the deadline to get a new law passed. Lots to talk about, but first, let's tee up the topic.
Canadians across regions, age groups, and political leanings want expanded access to medical assistance in dying. In a recent national survey, 70% supported removing the requirement that a person's death be reasonably foreseeable for them to access MAID, while over 8 in 10 Canadians believe people with degenerative diseases, including dementia, should be allowed to make advance requests. And among respondents with chronic physical or mental conditions, 84% favored allowing advance requests. While support was high among all ages, Zoomers were the most amenable to broadening access.
Don Middleton's life took an unexpected turn last year, and he reached the point where he wanted to die. But he faced hurdles in seeking medically assisted death, for which he is now thankful. Here's his story.
Not being able to see any relief or light at the end of the tunnel for the depression, it's very easy to choose. As I said to them, the exit to the morgue looks pretty comforting at the moment.
After decades of relatively good health, 91-year-old Don Middleton suffered heart failure and found himself in a Catholic hospital where his requests for medical assistance in dying were largely ignored. Even worse, he found himself in an environment where a faith agenda was his only option.
Though I must say, don't try to actively seek that outlet in a Catholic hospital. They offered me last rites. I will say they did that. So when I informed them that last rites were not high on my list of this Protestant, they offered me a chaplain. The day before Christmas, I got a little wrathy and said, I'm out of here. And on Christmas Eve, I was moved to Bridgepoint.
But once in a new environment where his wishes were being respected, Don's condition slowly improved. And with the support of family and friends, his desire for medical assistance in dying slowly began to diminish.
But the real help came from people who visited me, who had been beside people who made the exact decision I was making. And that was very supportive. It was non-judgmental. They had not necessarily agreed with their partner's decision, but they did not deny them the right.
Now Don is back home where he continues to gain strength, and with plenty of love from friends, family, and his partner, Mino Jose, he has a new lease on life.
Without the delay, I would not have found another direction. I'm a long way from that at the moment. My heart will sustain my present level of activity, I think. I celebrated my 91st birthday in the hospital, December 3, and the nicest thing happened on my birthday. Mina's niece had a son born on December 3rd. So really an important part of the Jose family. So there's always a sunny day ahead if you have to look at it even through the rain.
So I'd like to get everyone's reaction to what we just saw, starting with Celia. And Celia, your husband made a different choice, and he actually went through with medically assisted dying.
That's right. Yeah, that was just 2.5 years ago now. And he had been quite ill with cancer for about 6 months prior to his decision. Although he'd been diagnosed around the time of the Carter decision, actually, which opened up the opportunity for Canadians to have medically assisted death. As his health got worse and worse, and unfortunately, so did his capacity for making that decision. And so at the end, it became a bit of a race to see whether he was going to continue to maintain the capacity in order to make the decision to die, or whether he was going to run the clock out, as it were, and lose that capacity.
Okay, Helen, what's your takeaway? In the case of Don, the clock didn't run out and he changed his mind.
Yeah, I think Don's story actually reflects a number of Canadians that we hear from. Many people just having that sense of control and the ability to make the choice is enough for them at some point in time. So ultimately, everyone that we talk to, everyone who starts out seeking MAID, doesn't end up having a MAID death, and that's fine. That's what worked best for Don, and it's great he was able to experience the birth of that new niece.
Dr. Perreault?
Yeah, it sounds like Don made the right decision for himself, that he, in the course of doing the assessments, he received the information that he needed to make a decision that was right for him, and he's clearly very pleased with the decision that he made.
Pamela?
I think both stories, as we heard from Celia and from Don, speak to the very core of this issue, which is it's a matter of choice. It's a question of choice for every individual. And the process to go through this does not allow for some kind of spur of the moment decision. It's long and thoughtful, and it engages the medical profession and family members. And I think in both cases, the outcome was what each of those individuals chose. And that's what we're looking for, the right to choose.
I have a slightly different take on this. I think this illustrates that it is not only a matter of choice, and it's a matter of safeguards. If you listen to what Mr. Richardson is saying, he is saying that had things gone differently, had there been a shorter period of time, for example, he would have chosen differently. But instead, he had the opportunity to get better. And that's one of the things that we risk losing as we lose safeguards. The other thing that I think is very important in his story is that what changed for him was that he had a change, not in his illness, but in the things around him that gave him a purpose for living. And that is something which, again, I think we are lacking as we expand MAID laws. It's a tension between one person's choice and the risk it puts somebody else at of enacting a permanent decision to end their life when they would have later changed their mind.
Trudeau Lemons.
I think indeed that the story makes clear the ambiguity that people face when they are approaching death, and that if you have important services available, good palliative care, good services available, that this may actually change the decision that people make when they are approaching death.
Okay. We'll dig deeper into the issues after the break. Stay with us.
You do have people who are suicidal, who get MAID, who would have actually gotten better.
It's unconstitutional to deny people this choice.
Welcome back to theZoomer. As it stands now, Bill C-7 would greatly expand the right to MAID by eliminating the requirement that a patient's death be reasonably foreseeable. Back in 2015, Kathy Wardle had to travel to Switzerland for her medically assisted death. She made the decision after living with debilitating pain for more than 10 years. She died without the comforts of home and with little hope that the government would change the law anytime soon. And she was right. This is an excerpt from the Vision TV documentary, My Life, My Choice.
It just seems criminal to me that I have to leave my land, I have to leave my bed. I can't be honest with my friends and explain to them what I'm doing and why. I have to go kind of in secret and go all the way to Switzerland to accomplish something that should be easily available to me as a Canadian citizen. It was available to my dog. And my dog died a beautiful, gentle death in my arms. And I would love to be able to do that here. It's not fair.
You can see the full documentary on visiontv.ca. And according to the Quebec court, having the requirement that a patient's death be reasonably foreseeable is unconstitutional. But critics argue that removing this barrier in C-7 will undermine the rights of disabled people or those with mental illness and make it more likely that assisted dying will be offered before treatment and support. Trudeau, you were speaking to this before.
Yes, so Bill C-7 removes the reasonable foreseeable death criterion based on a Truchon decision, which is interestingly was decided in Quebec, where the interpretation of the reasonable foreseeable death criterion under the federal law was already more narrow than in other provinces. So the plaintiffs in the Truchon decision actually would have had access to medical assistance in dying in BC and Ontario, for example, based on the interpretation given. We have a law that already allows people who are broadly approaching their natural death to apply for medical assistance in dying. Now we have abolished that, and we actually will only provide medical assistance in dying for people who are not close to their death, who may have years or decades of life left when they have a disability. So we're singling out people with a disability, and we're sending the message with Bill C-7 that even if you have years or decades of life left, we, the state, the medical system, will actually facilitate your dying.
Pamela, do you agree that removing this provision focuses in on people with disabilities?
I think that it is a real misunderstanding of the entire discussion and certainly of the legislation specifically. Everybody who's engaged on this file and who is coming at it from whatever point of view wants to ensure, and we have certainly in the Senate asked for the government to make sure that there is the adequate kind of support that people need for mental health issues. But there is nothing in this legislation that says someone who is disabled or mentally ill is going to be forced into this. This notion that somehow someone else can make this choice for you is just plain wrong. Anybody who is explored the process at all knows that it requires the involvement of medical professionals, of your family, of assessors, MAID assessors who are specifically trained in this. It's a long process. It's not just call up and have someone impose this on you, but we have to do, I think, what the Supreme Court said in 2015, which it's unconstitutional to deny people this choice.
The way that clause will be written in C-7, who do you think will get access that doesn't have access now?
Well, I think anyone with a grievous and irremediable condition, which isn't necessarily a disability, it could be another chronic condition or illness, will now have the same rights that other Canadians have to access medical assistance in dying. So we see this as, Justice Baudouin spoke to it in the Truchon decision. This is making sure that all Canadians have equal opportunity to access MAID if they're eligible, and that everyone's assessed on a case-by-case basis as opposed to being judged as part of a group.
Dr. Gand?
The idea that this will not put certain populations at risk that are vulnerable is simply not true. And that's based on evidence we know. This is not based on speculation. And what we know is this, that the MAID that has been provided so far in Canada and North America when end of life is reasonably near, that the population that takes advantage of that and wants it is more privileged. It's people who are better off, people who are better educated. They also do tend to be Caucasian. When you expand it and you look at what happens in MAID in Europe, in the few countries that allow it, and people get it for mental illness, it's a different population. It's a population that is suffering from life stressors of loneliness and isolation. It is also a population where twice as many women as men get psychiatric euthanasia, unlike here, where it's 50-50 when end of life is reasonably near. And the very frightening thing about that to me as a psychiatrist is that that is exactly the same ratio of women to men who attempt suicide, but they end up typically not successfully completing it, and they don't try again. So what we are actually doing is we are providing lethal means to people while they're suicidal. And the final piece I'll make on this is that once again, the evidence shows us that when you look at psychiatric euthanasia, we cannot tell apart people who are suicidal in the traditional psychiatric sense from those who seek MAID for reasons of autonomy, which is what people talk about MAID expansion for. And you do have people who are suicidal, who get MAID, who would have actually gotten better.
We'll have more on Bill C-7 when we come back. Stay tuned.
It troubled me that we kept excluding this one group for whom it is so important.
When Bill C-7 went to the Senate, they proposed amendments which would have broadened access to MAID even further. One that's been scratched for now is the clause allowing for advance directives. Canadians overwhelmingly support the concept of being able to predetermine the conditions under which they choose assisted death. For example, over 80% of CARP members support advance requests for grievous and irreconcilable medical conditions like dementia. Pamela, you were part of the Senate committee that drafted the amendment for those directives, and it's not going to be in the current bill, but why is it important to you? What's your story?
Yeah, this was a very personal, it was not an issue actually put forward by the committee just as a process matter, but we tried very hard, a group of us, the last time around when Bill C-14 came forward, to really ask the government to explain why they were targeting a particular group of people. And that is the group of people with dementia or cognitive impairment of some kind. It's kind of a catch-22, which is before you're diagnosed with dementia or Alzheimer's, you don't qualify under the old bill. You didn't have a condition that would justify this. And then once you are declared, your diagnosis is given, you're declared incompetent because you have a cognitive impairment. So it troubled me that we kept excluding this one group for whom it is so important. Many of us, myself included, have lived through this with a grandmother and a mother. It is a situation I will likely face in my life. And so this notion of an advanced request where you can start to go through the process so that medical professionals, your family, everyone else knows, I think becomes important. The thing is that this bill has recognized this notion by accepting Audrey's amendment that your death doesn't have to be reasonably foreseeable, and you want to be able to make this ask and this claim, even though in the final moments you may not be able to consent. And it's the same principle we have for DNRs that have do not resuscitate orders, that if you're in a car accident or you have a stroke, that your wishes have already been made clear in advance, that there are circumstances in which I do not want to be resuscitated or I don't want extreme measures. So the principle is recognized. The government says, oh, it's okay in that circumstance, but they are punishing and excluding a large group of people. About 500,000 Canadians are suffering from or will be soon diagnosed. And we have to figure out how to deal with that group. And the government's rejection of this, to me, is both puzzling and as much as it is discriminatory.
Dr. Gant, how do you see that, the possibility of an advance directive?
I think this is one of the most challenging areas because, I mean, look, let's be honest. Any of us who picture our futures and think, if this happens or that happens, would I like to not be here? Would I like something that provides me relief from something that is an otherwise a state of suffering? The challenge becomes this. It's easy to give an advance directive and say, I want something in the future. But once you lose capacity, how do you change your mind? And there's nothing that is come up that adequately addresses that. And with respect to Senator Wallin's comment that this is no different than DNRs, that is simply not true. You know, a DNR, I'm a physician. I've worked my whole life, not just in psychiatry, but psycho-oncology, dealing with dying patients and their families. And a DNR is simply something that's different. That is that's when somebody doesn't want aggressive treatment to try to keep them alive. When we provide death to someone who isn't dying, I don't see how that's the same as a DNR. Now, it doesn't disqualify.
The principle is the same.
Those issues,
that's
but,
what I'm arguing. Yeah.
But so it's not. But I think this case illustrates what the concern is, and I don't know how I personally feel about this, but I think people need to understand what the actual issues are and what the risks can be. I think we just need to understand that suffering is a universal phenomena, and the way we address it for all of us needs to consider how it might play for others of us as well.
Dr. Perreault, how do you see this?
I think it's perfectly appropriate to have advance directives. I think that someone can very clearly outline the conditions under which they would want to receive MAID, and that could be discussed with their families. It could be clearly written in their advance directive, and it could be carried out by a physician. I think another important thing to consider is just how detailed these MAID assessments are, how much time they take, how thorough they are. The possibility of someone receiving MAID who did not want to actively seek MAID is so remote as to be unbelievable to me.
I just want to get very quickly from Celia, because you were talking about this race not to run out of the clock for your husband. So do you think that having this provision would have made things easier, or how do you see that?
I've thought a lot about this. And while on the one hand, it would certainly have made it easier in that we wouldn't have had to worry about that final capacity assessment at the time of the injection, it would also have been extremely difficult for me then and my husband's children to make that decision at the end to proceed, because I think it ultimately would have fallen to us to ensure that the doctor was prepared to deliver the lethal injection. While I certainly do agree that advance directives would be a good idea, I think it would be difficult for families.
Okay, there's lots more to discuss. Stay tuned.
There will be people who would have gotten better, who will now have their life ended.
The sense that there's no safeguards is just really not, I don't think it accurately reflects where the communities are.
Welcome back. The Senate also believes that people suffering solely from mental illness should also have access to MAID. The original bill would have included a blanket ban for those with incurable mental illness. The Senate wanted that ban lifted after 18 months. The House agreed to remove this restriction, but not for 2 years. So what are the concerns with doing that, Dr. Gand?
So the concerns are that when we do something in medicine, it really should be based on evidence that shows us what is safe to do and what is dangerous to do. And what we've been told MAID is for conditions that are irremediable, meaning conditions that will not get better. What we will be doing is taking lives of non-dying marginalized people who have life suffering, who would have gotten better. That to me is quite a perverse equation. And look, I'm a physician. I consider myself one of the privileged, like most of us, I would say, on the panel. And sure, I would, and by the way, I believe in MAID. I am the physician lead of my hospital MAID team. I see the benefits that MAID brings. I believe in it. And I'm terrified of the dangers of reckless expansion, because I also see those risks.
Pamela, what argument convinced the Senate that MAID could be expanded this way without putting all these people in danger?
Well, one of the arguments is the one I mentioned earlier, that it's discriminatory and unconstitutional. That is according to the Supreme Court, but it was a psychiatrist himself who put forward this amendment, Senator Kutcher. He works with those with mental illness. This sense that there's no safeguards is just really not, I don't think it accurately reflects where the communities are. Everybody's very, very sensitive to these issues that mental health may be a transitory condition or depression, but it is not the case for those that might have an extreme condition or bipolar and may have to spend the rest of their life on medication. And they want to choose not to do that because that has taken away their soul and their creativity and their view of living.
Dr. Perot?
There is no cure for mental illnesses. They are grievous and irremediable conditions, and for many people, they cause extreme suffering over a very, very long period of time. We're not talking about opening up MAID and providing MAID to people who are in the throes of an episode of a mental illness, whether it's schizophrenia or bipolar disorder or a major depression. We're talking about people who have been living with and suffering from their mental illness for many, many years, who don't want to go through another cycle of it. So we would be assessing people when they were not in an acute episode, when they had capacity to give informed consent and to think about it very deeply and very thoughtfully, to look at their life spectrum and make the decision that I've lived through this for X number of episodes of up and down and in and out of hospital or suicidality or whatever it is, and to decide that they don't want to spend the next 10, 20, 30, 40 years living in that way. So it's important to distinguish between a suicidal thought, a suicidal gesture, and the request for MAID. And I agree with Dr. Gaynor that in some cases that may be difficult, but I think it's not impossible. And in the vast majority of cases, it will be much more clear. And I do think that the legislation should be opened up to people for whom mental illness is the sole underlying condition.
Trudeau Lemons?
Yes, so the argument that the exclusion of mental illness is discriminatory and is somehow not in line with Carter is incorrect, in the sense that the Carter decision explicitly mentions in its reasoning that they're not talking about medical assistance in dying, physician-assisted dying in relation to mental illness. So they did not discuss this issue in relation to mental health. We know from the two countries where we see physicians ending the life of people with mental illness, Belgium and the Netherlands, that the people who have access there for reasons of mental illness are not the type of people who are asking for medical assistance and dying close to the end of life. They're vulnerable people who suffer from existential problems, from loneliness, from relations breakup, from loss of friends, family members, from economic hardship. So these are vulnerable people who suffer in addition of that from mental illness as well. It's clear that there will be people who would have gotten better, who will now have their life ended. So I would say there's a reason why so few countries have actually, even countries who recently legalized some form of medical assistance in dying, have extended it outside of the end of life context, and particularly in the context of mental health.
Helen?
Yeah, I think, some would argue that the 2016 case of EF in Alberta actually did point to the Carter decision as granting MAID eligibility for those with a mental illness. So there is some precedent for that. And I think, the points raised about what goes on in other countries, hopefully those are things we can learn from and be sure we're aware of and cautious of as we're developing the regulation and legislation that supports this change.
Dr. Gand, you wanted to jump in?
Yes, thank you. I appreciate that. I think that it's important to recognize here that mental illnesses absolutely can be grievous. I've devoted my life to trying to help people not just get better, but live with their suffering as well. And when the Council of Canadian Academies expert panel on mental illness and assisted dying spends 15 months, on which I sat, so I full well know this evidence, spends 15 months searching for evidence about whether we can predict irremediability in mental illness. In other words, when you're not going to get better and we can't find it, that says something. When CAMH, our most esteemed scientific mental health institute in the country and perhaps North America, says the same thing, I believe it. And when Senator Kuchar or others say they think that they can predict it, well, that's their opinion. It's not evidence. It's not science. And a sunset clause cannot force evidence to appear into existence any more than I can say, I want coronavirus gone in a month. It's impossible. And the science does not support it, notwithstanding independent psychiatrists who may think they know otherwise.
How much of the evidence explored with patients themselves who have lived with these mental illnesses for many, many years? Were they consulted in all of this?
Yeah, actually, many of the patient groups are very worried about this. And in fact, what I would say is that your question strikes at a very important point, which is, why don't we have that evidence? Why are we, we were supposed to have a parliamentary review to properly.
Yes, and we didn't have it. That's the problem.
Right, and so now we're saying,
were you allowed to
pretend
make
evidence.
recommendations?
So why don't we find that evidence first before saying we're risking vulnerable lives?
My patients would be very upset at the idea that they don't have the right to make their own decisions about their own lives and how they live with their illnesses. But it's their values and principles and goals for their lives that should reign supreme, not those of medical providers.
Okay, Pamela, I know you want to jump in, like 20 seconds.
Yeah, I think that's exactly the point, that the process was not, the government did not do what it said it would do, which is undergo and undertake that public assessment. The Council of the Academies met, but they were not allowed to make recommendations. So what the Senate has asked and what Senator Kuchar has asked is to go to those people that are involved in this and go through that precise procedure so that people who are living with mental illness have a say.
Okay, more to come after the break. Stick around.
Many Canadians just want to explore the choice and understand what it means for them.
Between 2016 and 2019, nearly 14,000 Canadians chose medically assisted death. In Quebec, nearly 2.5% of all deaths now are classified as medically assisted. In BC, that number is nearly 3.5%. So there's a question. How will those numbers increase with greater access? And again, how will we be sure that those safeguards stay in place to prevent abuse?
No, I think it's impossible to predict that. Certainly BC, has higher numbers. They also have the largest group of MAID assessors and providers, so that does make some sense. I think we're certainly seeing heightened interest in medical assistance in dying. But I said earlier, many Canadians just want to explore the choice and understand what it means for them.
I couldn't predict any numbers, but I do think there will be more people who will be exploring it and wanting to include it in an advanced directive if and when that becomes possible.
Trudeau-Lemons, do you think that the dangers that you see increase with this increased access?
Canada, under Bill C-7, will not even require that a physician, for example, has to agree that all reasonable medical options for relief of suffering have been met have been tried out and haven't succeeded. In other words, you can have somebody who feels desperate, who gives up on life, who has years or decades of life left, if the physician would be able to say, well, I hear you, but let's try first the available therapies that we have that we know will likely relieve your suffering. Under Bill C7, a patient will be able to refuse that and will be able to insist that they have access to medical assistance and die. It's unprecedented on an international scale.
That's where there's a fundamental error in the interpretation of the application of the law. No patient in the throes of a mental illness, in the throes of desperation, would be found eligible for MAID, which does not mean that they have to try any treatments that are offered to them. You can't force someone to take treatment that they don't want to treat, but if they're not capable of making the decision, they would not be receiving MAID.
I think that's where we need so much more education about this process. The assessment process is very significant. This is not just one call, one visit to the doctor, and you make a decision. There is a process, and I think the issues that we need to deal with are accessibility.
Celia, again, through the lens of your experience, what do you think about the expanded access?
Well, I have to put my faith in the safeguards that are there. I felt they were pretty rigorous when Jack was being assessed. It was a couple of long interviews, and interviews where I was asked to leave the room so that it was clear that these were his wishes, not I wasn't imposing my will on him or anything. The witnessing process, I mean, at least it assumes, it ensures that there are other people involved. All of these safeguards, I think we have to have faith are going to be carried out properly. And I know in the case in my husband's case, they certainly were.
And Pamela, just before we break, 20 seconds, what is going to happen to that bill now?
Well, we either accept the rejection of some of the amendments, or we just or we go another round. We usually in the Senate allow the elected representatives to have a greater say, but this is a very personal, ethical, moral, profoundly touching an awful lot of people, and they may want to have another round of discussion on this.
Okay. When we come back, final thoughts from our panelists. Don't go away. Welcome back to theZoomer. It's time for final thoughts. We'll start with Celia.
Thanks a lot, Libby. For me, it's just really exciting that this issue, which was so important to my husband, is getting so much more attention as time goes on, and the window appears to be opening gradually, and I think he would have agreed with that too. So thank you.
Dr. Gand?
Thank you. And appreciate the chance to discuss this topic with you. But my final thought is that in terms of where we're at, we are looking at shifting a framework that was intended to help relieve suffering and avoid a painful death into one that provides death to help the marginalized avoid a painful life when they could have gotten better. And that to me is terribly troubling.
Pamela.
87% of Canadians want this right. They want the ability to choose. Having lived a life in dignity, they want to be able to end their life with the same dignity. Watching family members lose that dignity, I feel even more strongly as each day goes on, that this is such an important debate. When people lose their sense of who they are, who they once were, it's every bit as serious as if they are suffering from some other physical illness. We have to understand that this is a profoundly personal matter of choice.
Dr. Perot?
And until this debate, I was not as aware of the antipathy that the parliamentarians hold for the Senate, and I find that quite distressing. And it seems that, at least according to the Ipsos poll that came out last week, that the parliamentarians who are supposed to represent the people are quite out of step with the vast majority of the people of Canada across all demographic groups who do want an expansion of MAID eligibility.
Trudeau.
at the time of the pandemic, when people are already opting now for or desperate for solutions, radical solutions to their suffering, that is a very bad time to zealously push this through without trying to learn what we already see is in the context of medical assistance in dying, what's working well, what's working less well. So I would say it's premature and it is a irresponsible move at this time, particularly during the pandemic.
Helen.
Yeah, I think for us, this is about three things: compassion, intolerable suffering, and personal autonomy. We hear from Canadians every day. Their thoughts were echoed in the 300,000 responses the government got last year, in the Ipsos survey that was spoken to last week, in all of the Senate and House hearings that have been held. I think parliamentarians at this point need to hear what people are asking for.
These are tough emotional issues which we must all come to terms with, and the conversations will continue even after the law is settled. Thank you to my panelists for being here and to our audience at home for watching. For now, it's time to zoom out.